Hello again, this is Randy Catanese of Catanese and Wells, and today I want to talk about mediation in the context of trust and estate litigation. What happens with trust and estate litigation many times is the idea of mediation comes up after the parties have spent an awful lot of money on pre-litigation, litigation, and sometimes post-litigation, meaning after a hearing before a judge or even a trial before a jury. When you are involved in estate and trust litigation, there's going to be certain windows that appear in the case regarding mediation. One of those windows is going to be before a lawsuit's filed by somebody, and this is where you have an opportunity to direct a resolution that you have some control over. Many times early mediation is difficult only because the parties are suspicious of each other. There hasn't been any real discovery. The parties are hesitant to exchange the evidence or information they have because they think they'll lose an advantage. And many times an early mediation results in frustration for the people involved. If you go to mediation too early, you show up and it might be a retired judge, it might be an attorney who's very knowledgeable in the area, and when you arrive, the attorney or the judge will ask, okay, well, what evidence do you have to support your claims? And oftentimes there really isn't all that much evidence other than speculation, innuendo. Maybe there's some family members or friends or witnesses who might be available to say certain things in support of a position, but many times the mediation comes down to he said, she said. In one room is a group of people saying one thing, in the other room is a group of people saying another thing, and the mediator's trying hard to resolve the case, but they don't really have the tools to get it done, meaning evidence, witness statements, expert witness testimony, documents to show that somebody did something wrong, bank records. And so sometimes what happens in these early mediations, absent that type of information, the mediator cannot get it resolved. However, if it doesn't get resolved, sometimes what happens is the parties identify what information would be helpful. And so many times you can have a second session scheduled, and between the first and second session you agree, all right, let's go get this information, we'll provide it to the mediator, we'll provide it to each other, and we'll use that information to help us resolve the case. And so that's one part of when you could do a mediation. The second time or a window when you can do mediation is after the litigation starts. In California, particularly in the superior courts and also federal court almost anywhere, the court wants the parties to settle the case if it's practicable. The policy of the law, state and federal, is to encourage people to settle because of judicial economy and for a lot of reasons, namely saving time and money, less burden on the judicial system, and also allows the parties to fashion a resolution that they have some control over. Many times in cases that I've been involved with, the court will say to my clients and to the other side, why do you want a stranger to decide the outcome here? Meaning me as the judge or a jury. Wouldn't it be better if you could work with the other side and the two of you fashion a resolution that you have some control over? And there's a lot of truth to that statement. So, second window for mediations, after the litigation starts. There will be a time in the litigation where the court will order a mediation. That's not the same as an arbitration. Arbitration is like a trial with a final result. Mediation is a voluntary participation in a dispute resolution situation, and many times it's called alternative dispute resolution. Also, another thing to remember in mediation is everything that's discussed is confidential. It's not disclosed to the court. It's not disclosed to the other parties unless you authorize the mediator to do that. And the other thing about it is the court who is handling the matter, the trial judge, they're basically told whether the case settled or did not settle. And that's pretty much it. Not the reasons why it didn't settle or what the parties said in the mediation, which is prohibited. So it gives the parties an incentive to be open, to work with each other. And again, policy of the law is to encourage people to settle, so communication is protected and not disclosed. Second window usually happens sometimes after some discoveries occurred. So it could be 6 months after the litigation starts, could be 8 months after it starts. Sometimes there's a bombshell revelation that happens. Some witness comes forward and says, I was an eyewitness to so-and-so abusing mom or so-and-so abusing dad. I'm an eyewitness to them taking jewelry out of the safety deposit box or taking cash or manipulating them by not feeding them. All the different things that people claim as to maybe why a trust isn't enforceable or a will is not enforceable. And so the next window usually is after there's been some discovery. When that window happens, there's a higher chance the case will resolve because the parties are somewhat satisfied that they've had a chance to conduct discovery and they've had a chance to look at the discovery and consult with experts to get their opinions as to what they feel about the case. For example, did mom have dementia? Was there undue influence over dad? Was there a situation here where the deed, a deed or a trust or a will is the product of fraud, meaning it's false, it's a forgery. And sometimes it takes discovery and expert witnesses to find out whether or not some of those allegations have some merit and whether or not a judge or an attorney can convince the other side that, look, if you go to trial on this, given the state of the evidence, at least that we see right now, there's a good chance you could lose. And sometimes that's enough to convince somebody to resolve it. And finally, the third window for mediation, which sounds unusual, is sometimes you go and you do a case before the judge in probate and estate litigation. And by the way, in California, probate and estate litigation is solely before a judge or a judicial officer unless otherwise provided by statute. In California, there is what we call financial elder abuse claims or financial physical abuse claims. And under the Welfare and Institutions Code, you as a petitioner or plaintiff can ask for a jury in some limited circumstances by reason of that statute. But sometimes what happens is you do a trial with the judge, and the judge issues what's known as a tentative statement of decision. This is in California. Once you read that tentative statement of decision, sometimes what the court will say is maybe you all should think about going to mediation and resolving the case. And if the statement of decision is really bad for one party or the other, that usually doesn't work. But if it's kind of in the middle, it gives the parties an indication of what the judge is going to do, and sometimes it encourages them to do a mediation, even at that late point in the litigation, to resolve their differences, again, so they can have some control over the outcome. So I hope this information has been useful to you. Again, always feel free to give our office a telephone call if you have any questions or comments. Our office number is 818-707-0407, and my name is Randy Katniss. I'm the lead trial attorney at Katniss & Wells. Thank you for your time.